Welcome back, ladies and gentlemen, to another episode of Lassiter Law, here with my co-host, Lacey G.
And I'm here with the world-renowned Mark Lassiter, who was making so many moves the other week. I can't wait to hear, has there been any updates?
Well, there actually has, as far as that case is concerned. But today, what I wanted to talk about is motions to revoke. So we have talked about probation in previous episodes, but just to give our audience kind of an overview of what we're going to talk about today. When you are put on probation, if your attorney works out a deal with you where you are going to get what is known as probation or a deferred probation, which is a deferred sentence, meaning at the end of it, the case is dismissed, but it's still on your record. And you're still serving the same type of format. It's probation. You are reporting to a probation department. When you get a probationary sentence, what happens if you do potentially something wrong? In other words, something that's against the rules of probation. So for our audience to understand, let's just take a simple DWI, for example, or a drug case or anything like that. Most of the time, there will be what's called conditions of probation. Conditions of probation are when the judge says, you can't do this, you can't do this, you can't do this. And they're what you might think of. You can't do drugs, you can't do illegal activities, you can't get arrested again. For DWIs, a lot of time it's you can't drink alcohol. For possession cases, it's like you can't, and for most of them in Texas, you can't use illegal substances, which includes marijuana, Adderall, unless you have a prescription for it, and those types, Xanax, unless you have a prescription for it. You can't hang out with bad people, right? People that are known to be criminals. You have to report once a month, typically. For DWIs, there are conditions that you have to do a DWI education class. You have to do a victim impact panel. You have to do a alcohol evaluation just to make sure that you're not prone to drugs or alcohol. And if you are, then what will happen is the judge will order continuing treatment of whatever degree he deems fit, inpatient, outpatient. So these are the standard conditions of probation that you are put on.
And if you violate any of those, they can find you.
Typically, what will happen is you have a field probation officer. Now, that field probation officer reports to a court probation officer, and the court probation officer is actually your probation officer. The field probation department is the one that you just check in with. They are the ones assigned to your case to monitor you in the field because your probation is transferred to whatever county in Texas that you live in, and then to a probation department location that is closest to your location, your home location. So you report to the field probation officer. And let's just say, for example, you fail to report. What happens next? Your field probation officer will give you a call at a number that you have provided at the beginning of probation and says, hey, this is how you get a hold of this person. And that field probation officer will then ask you, hey, what's going on? Did you not report for a reason? And many times the clients abscond, they just disappear. And then they get scared because they didn't report that a warrant's going to be issued. And then they just never report again. So people, audience, let me tell you this, report when you're supposed to report. And if you don't report, call them and tell them why you didn't report as soon as possible. Let's go to a separate offense. Let's say they call you, and for many types of drugs or alcohol related offenses, they say, we want you to come in and take a drug test. A lot of people freak out because they're like, hey, we've used marijuana in the last 30 days, and they don't show up for the drug test. So because they know they're going to do what's termed as peeing hot or peeing positive for an illegal substance. So they just choose, hey, we're just not going to pee at all. And that's not a good plan, because what happens then is they do a violation for failure to come in and take the test when you are required to. That's one of those conditions of probation. Hey, we can ask you to take a test at any time. If you don't do that, that's in and of itself a violation. In those certain circumstances, what I would tell the audience is call your attorney or find an attorney because there are ways in which sometimes that attorney can deal with the probation department or the district attorney's office before it becomes a problem. So in those instances, try and fix the problem before it's a problem. But if you try and fix it yourself, what will happen is the field probationer officer will call you in, you come in, and they'll say, did you do this? And you say, yes, I did. That's why I didn't want to take the test. Well, then you now have given an admission, which is in essence a confession, which can be used to violate your probation. Don't give them that information. That is against your best interests.
You should call an attorney.
You should call either your former attorney or a new attorney if you didn't like your former attorney, because you need advice on what to say and when to say it.
Mm-hmm.
And that attorney, rather than doing an admission, might be able to call that field probation officer and say, hey, we understand they didn't show up for the test. This is why, insert whatever excuse you want to insert there. Can we just make up that test right now? Maybe they'll let you do that. Or you know that your client, as the attorney, is not going to be able to pee clean. And so you say, look, we had a relapse. Here's what we're doing to treat it. Is that sufficient for you? Don't file a violation unless you have to. And the probation officer can respond, yes, that's fine, or no, that's not. And the attorney then, without making a confession, can then provide a way in which you can deal with the issue without it becoming a bigger issue. All right. So fast forward, what happens if you go in and you've already peed hot, right? How do you address it then? Well, you still do the same process. Call your attorney or a new attorney and say, hey, I went to a test and I'm pretty sure it's going to be positive, or I was notified by probation that it's positive. What do I do now?
Mm-hmm.
Well, then the attorney would do the same thing. He would try and operate to try and resolve the matter before it becomes a violation. What you are trying to do as a good lawyer is you're trying to prevent it from getting to the filing of a motion to revoke. Because once you file a motion to revoke, the probation department would send this. They say, here's a violation. The field probation officer sends it to the court probation officer. Then the court probation officer reviews it, makes sure it's a violation, then sends it to the state, which is the district attorney's office. The district attorney's office then reviews it, makes sure it's a violation, and then signs off on this. Having been a prosecutor, let me tell you the real process is the court probation officer gets something from the field probation officer in the form of notes. They then copy and paste it onto a motion to revoke, go over to the DA, put it in front of the DA, and the DA just starts signing one after the other, one after the other, one after the other. They'll sign 30 in a row.
That sounds like a lot of paperwork. I thought it was hard to get evidence and stuff, but then they'll do paperwork as they want to.
The field probation officer will say, let's just use Pete Hot for an example. Violation report, this person tested positive for marijuana. They send that to the court probation officer. Court probation officer says, motion to revoke, line item number 1, tested positive for marijuana. Goes up to the DA, sign this, DA signs it, they file it. Now there is a warrant out for that person's arrest because that gets sent over to the sheriff. Sheriff then sends it over to their warrant department and they serve the warrant.
If there's a warrant, does that mean like they show up at the home and arrest that person? They're driving around and could get pulled over?
Possible. Mm-hmm. Possible. So what happens when a warrant is issued? And I use the example that I used that some people just don't report and then just have a warrant out for years. Certain police agencies or sheriff's departments will go and serve warrants on a timely basis. Like, we got the warrant, we tried to serve it the next day. Then there are other sheriff's departments, not to name names, Dallas, that will get a warrant and they won't serve it for years. I mean, it's in their system and we'll see them when we see them, right? So to your point, driving around, they see that this person has a warrant when they check him out by running their license plate. Hey, the owner of this vehicle has a warrant. Boop, turn on the red and blue lights. They walk in, make sure that's the person. then you're under arrest for the warrant and whatever else they find in the car at that time. So, yes, that is possible that they could serve the warrant, and it is possible that you can get picked up while driving. All of this is up in the air. We don't know.
Confession. Early 20s, no money. I had no money and multiple jobs. I had gotten a lot of just traffic tickets, but I was unable to pay them off. And I was at home one day and a roommate came up to me and said, "Hey, there's a cop here asking for you." I'm so innocent, Mark. I went outside because I did not know I was about to be arrested for unpaid tickets.
Unpaid traffic tickets.
Unpaid.
Now, parking tickets, one thing, but traffic tickets, another. And yes, they will issue a warrant. And yes, they do these warrant roundups. So they come out and they arrest everybody on that they can find.
But I thought, like, I'm not in trouble. I don't do anything wrong. I wasn't clicking that, no, this is
a traffic ticket.
Yeah. And yeah, they picked me up.
And then you got to either pay the traffic ticket or you got to serve the time in jail for the traffic tickets, which really sucks.
Yeah. All of a sudden I came up with that money.
It's funny how that works. But for normal people, that's what happens. If we're talking about motions to revoke, though, I want to be clear that the attorney can't always work it out. If you report it to your attorney and they call, and a perfect example of this is something that happened to me the other day. I call the probation officer and I say, look, this doesn't need to be a violation. This is actually a legal drug. For instance, CBD oil is legal. You can take a legal substance and it tests positive for an illegal substance because hemp is legal in Texas. However, some of the probation departments have not realized that can happen, and they proceed with a violation because in that case, there's THC. Well, if there's THC, it doesn't mean that it's Delta 9. So to understand better, THC is carboxy 11. It is a chemical element, right, that is a derivative of the marijuana flower. But it's not what gets you high. And high being has a psychoactive component. That's the Delta 9. And sometimes the Delta 8, which is actually legal in Texas, but will still have you test positive for marijuana because they're testing for THC, not for whether or not you're high under Delta 9. So all of this to say is that when the attorney calls and tries to explain this to a probation officer who may or may not have any real world experience, they just kind of go, according to our rules, we're going to have to file a violation. Whether it is or not, you can duke it out with the judge. So then it goes to the court probation officer, in which we say, hey, can you work with us on this? The court probation officer says, no, according to my supervisor rules, I just have to file the violation. Okay, well, sometimes you get one of those and you can't work it out. So then the smart attorney calls the district attorney's office and says, hey, don't file a violation on this. This is nonsense, right? You don't need to do this because XYZ, insert whatever reason you want. District attorney may not be reasonable because they're new, or they don't think that it actually is a violation, or they don't buy any of the excuses, whatever. Well, then hope is not lost, ladies and gentlemen.
Not with Mark Lassiter. Right? We know that for sure.
With a good attorney, you don't need to be all of a sudden sweating, hey, I'm going to prison. That's not what a motion to revoke means. What a motion to revoke means is that the probation department and the state of Texas is alleging that you violated your probation by whatever item number they list, right? In this case, we'll use peeing hot as the example. You peed hot, tested positive for marijuana. Well, then the obligation is on the state of Texas to prove you committed that violation by a preponderance of the evidence. What that means is the judge does not have beyond a reasonable doubt as a standard. They can just say it's more likely than not, essentially, right? And what happens in these motion to revoke proceedings is the judge rules, not a jury. That's another important aspect of it. You don't get hey, they have to prove their case beyond a reasonable doubt to a jury. They have to prove it by a lower standard to a judge. And what that means for you is you need to know your judge. You need to know who it is and what their tendencies are like, whether or not they view marijuana as that big of a drug or not a big drug. You need to know these things because it affects what happens later.
Okay.
Because I am in front of different counties on a daily basis. And so the judges get to know certain attorneys better than others because they see them more often. And certain attorneys make more of an impression. I'd like to think that I'm one of those. And when I come in front of you, I make an impression. And so you remember that person. Unfortunately, when I was in the Army, they had this saying is that when you get through basic training, the goal is for the drill instructor to not know your name and say, "Who are you?" when he's pinning your medals on and saying you passed basic training. The drill instructor knew my name day one. Literally, I didn't make it a single day before that drill instructor was like, "Lassiter, what are you doing?" You know, and that's not a good thing. As per most things, it's my mouth. And it's because I have a tendency that if I see wrong, I tend to try and right the wrong. Well, a lot of the time in the Army, you're doing something not because it's very intelligent, but because they are trying to get you to obey an order, no matter what that order is. And if you disagree with that, you're not a very good soldier. So I had to learn very quickly that there are some orders that you just have to obey.
Mhm.
And that's how the military works, because it breaks down if you don't follow the instructions, because those instructions might be coming down the chain from 3, 4, 5 levels up. And if you don't do that one thing, which may not make a whole lot of sense to you, but you don't have the bigger picture. Well, in most cases, the lawyer, what they are trying to do is explain to the judge the bigger picture, right? The little guy, the probation officer, the field probation officer that filed the violation report may not understand that or may not have gotten that when the attorney was talking to them. So again, big picture here, when we talk about the motion to revoke, just because they file a motion and the judge then says, "Hey, I understand that there is a violation," by signing the warrant for your arrest, he is not saying he agrees with the violation report. What he is saying is, "I understand that there is a violation and the things alleged actually are violations if true." And so when you do a motion to revoke, the plea is not guilty or not guilty. The plea is true or not true, because you are saying these allegations made by the probation department are either true or not true according to you. So let's use the marijuana for an example again, because that tends to be the biggest violation that I see in my practice. They pee hot, test positive for marijuana. That's the only allegation in the motion to revoke. I tell the judge, not true. Now, we have to, prior to that point, usually bond out. And the bond out process is a lot different when it is a revocation, because you have already been booked in and arraigned previously. So you know the allegations and the charges. So all you have to do in that circumstance is usually go to the jail with the bondsman, post the new bond, and never have to go actually check in, book out of the jail. That is the normal process. Some sheriff's departments do it a little differently. Some police departments do it a little differently, but that is the normal process. So after that, you are entitled to a hearing, you, the citizen. So you, as the audience members, if you have a motion to revoke filed against you, are entitled to a hearing, and you are entitled to that hearing within 20 days if requested. Okay? That's important, because the reason that is in the legislative statute is because we don't want people sitting in jail for months at a time for an alleged violation. Either there is a violation or there isn't one, and the judge determines that. So in the case of a peeing hot for marijuana, we would ask the questions of the state of Texas. Hey, what evidence do you have that this THC is illegal versus legal substance? Do you have any evidence to suggest that? They may or may not have that evidence. Now, that's why you talk to an attorney before you go in, because a lot of my clients talk to me after the fact, and then they say, "Yeah, we went in and admitted after they told us we peed hot, this was marijuana." Well, you have taken that defense away from me. They have an obligation to prove it. They can't just say, "Hey, she peed hot." It has to be this was a violation. Now, some of the jurisdictions around Texas put in their probation, hey, you can't even use CBD products. That may or may not be in the conditions of probation. The other thing to realize is, what are you facing when you have a revocation? So, Lacey, in your circumstance where you had traffic tickets, you knew what you were facing because they said when you were arraigned, hey, you're up to X amount of time, 6 months in jail for this offense, or you can just pay the tickets. And you're like, oh, I'll just pay the tickets. So for a revocation, what you are facing goes back to your original plea paperwork. So your original plea paperwork will say something to the effect of, if you got probation, let's just say it's a normal DWI. You see this a lot. It's 1 year probated for 18 months or 1 year probated for 2 years. What that means is you are actually sentenced to 1 year in jail on a misdemeanor. For a felony, it'd be prison. And you are sentenced to whatever that first number is, 1 year, 6 months, whatever. In a felony, usually it's 2 years or more. Probated for whatever that second number is, 18 months, 2 years. So that's why they say, and everybody freaks out when they hear the judge pronounce the sentence. For instance, in a felony, sir, I sentence you to 5 years in prison, but I'm going to probate that for a period of 10 years. What that means for you, the probationer, is that your exposure, that means the maximum sentence that you can get is that first number. So if the judge says 5 years probated for 10, what that means is you have a 5-year prison sentence, and that is probated for 10 years. So if you pass probation, there is no jail sentence. If you fail to pass probation and they file a motion to revoke, then you have a sentence of potentially 5 years. Now, most people think that if you violate, I'm going to go to prison for 5 years. And that's why they freak out if they violate and they just run. But that's not what that means. What that means is it's your maximum penalty. So you can contest, and then you have a hearing to see if they are or they aren't. Let's say you lose that hearing. Do you automatically go to jail?
Do you?
No.
Okay.
The reason that you don't is you can do what's many attorneys do. They call it a true but. In other words, you say these violations are true. We violated probation by doing the things alleged. But, judge, don't sentence me to jail. Continue me on probation, and here's why. And you give a reason. And the judge either agrees with your reasoning or doesn't. And if the judge agrees with your reasoning, then the judge can say, okay, I find these allegations are true, but I sentence you to continue on probation, or I sentence you to continue on deferred probation. And what that means is all of your original conditions still apply, and you're just continued on probation. And in essence, there is no punishment other than the bonding out of the jail, which sometimes you can avoid by asking the judge for a hearing without having to do any type of a revocation proceeding. So if you want to avoid that hearing, sometimes you can do so by contacting the DA, and this is why you call a lawyer, contacting the DA and asking them to withdraw the motion to revoke. When you do so, the DA has an opportunity then, because normally they just sign. They haven't really looked at the details. So you provide the district attorney with the details and say, please listen to me, and then let it go. And for whatever reason that you give them. And sometimes the DA will do that. In fact, recently I was in front of the district attorney arguing that this didn't need to be a violation. They agreed, they withdrew the motion to revoke, and then we went in front of the judge. The reason we went in front of the judge is the judge has to sign off on the dismissal of in other words, the withdrawal of the state's motion, because the motion had been filed. In that case, the judge says, no, I don't agree. I want some sort of punishment. And so we sat there, and that's when the judge, as the officer of the court that is in control of your probation, the judge can add conditions as he sees fit. That is one of those things that you have to know as an attorney and as a citizen. So, members of the audience, if the judge says, I see a violation for marijuana, I'm going to order inpatient treatment for 6 months at this facility, he can do that, or she can do that. That is allowed. And you can't do anything about it as the attorney. When you took your probation plea, you said, Judge, you can add conditions as you see fit. That's one of the agreements that you make. So, all this being said, what I would tell everyone is that if you have a violation, start with calling your attorney. When that attorney goes through the process, get in front of the judge. The judge may say, even if this stuff is true, I'm still not going to find you to be responsible, and I'm just going to continue on probation. So essentially no punishment. Or the judge can give you added conditions of probation if they deem it necessary, or they deem it fit, or the judge can find the allegations not true. So I'm going to present a scenario to you, an interesting one, in which, I did this for a client of mine, and it worked swimmingly. And then the statute and the case law has been changed to now change that little little niche that we found in the law. So I represented a guy that was on probation in Dallas County who got another DWI in Harris County, so Houston, Texas. So guy gets a DWI in Dallas County, gets put on 2 years of probation. While on probation for DWI first, he picks up a DWI second offense in Harris County, so in Houston. And it violates his probation in Dallas County. They file the violation in Dallas County, alleging in a singular instance that he had violated his probation by being arrested for and committing the offense of DWI in Harris County. Now, he gets put in jail. For good attorneys, know the law. And I said, Judge, you have 20 days in which to hear this case, the violation. I would like a hearing, and we plead not true. So what that means is within 20 days, we are to have a hearing in which the state presents its evidence that he committed the new offense in Harris County. Now, why do you think I did that?
Well, for a fair and speedy trial, but also probably there's a chance that those 20 days would pass without something happening.
So here, and it's a very good, and you're on the right track, but here's why I did it. Harris County is a pretty good drive from Dallas County. Most of the time, after a DWI, it takes about 2 to 3 weeks to test the blood. Unfortunately for them, he just bonded out of jail in Harris County when they filed the violation, because as a probationer, you are supposed to report when you have a new offense, which he did, and they instantly filed a violation. So I knew they didn't have the proof that he was intoxicated. And even if they did, they'd have to work really fast to get up here. Within 3 weeks, they probably wouldn't even have tested the blood within 3 weeks. So within 20 days, it was unlikely that they would be able to prove, even on a preponderance level, that he was intoxicated. So what happens is we set our hearing date. Nobody shows up from Harris County. And the rules of evidence apply in a motion to revoke. All of a sudden, no evidence of a DWI. And that's the only allegation. So we demand that the judge find the allegation not true. Now, here's the rub. When a judge finds an allegation not true, and the only allegation is the criminal offense, a new criminal offense, under a lower standard of proof than beyond a reasonable doubt, a tribunal has ruled this not to be true. Under the rules of collateral estoppel, that makes the new DWI not guilty, because under a lower standard, it wasn't true. All because
Wow.
no evidence was presented. So we go down to Harris County and they try and present the case, and we're like, Judge, this is collaterally estopped. You cannot proceed. This case is not true. Harris County goes, wait, what? And then we explain to them, it's a little known area of the law, collateral estoppel, which we then used to win his new DWI. And that guy was not true and continued on probation in Dallas, and not guilty automatically in Harris. And boy, was he shocked.
That's really impressive.
And I had to convince him into it, because I had to say, look, if they bring the evidence, which they can bring, that you were intoxicated by, bringing a intoxication lab report and bringing the witness to testify to that and bringing the officer that arrested you, there's a chance the judge says, while on probation for DWI 1, you go out and pick up DWI number 2. No, I'm going to sentence you to the maximum, which in that case was 6 months in jail on the original DWI. So he had to be willing to risk 6 months in jail in order to get the result. But I said, hey, the risk is worth the reward. And it was in this case. So in most misdemeanors, though, even if the judge has the ability to sentence you to 6 months or a year in jail, 99% of the time, they don't do that. 99% of the time, you're able to convince the judge, hey, there's this other, if it's a first motion to revoke, there's this, and this that we can do to take care of the problem, and therefore you don't need to sentence them to any jail time. Now, there are instances where the judge may give you, the probationer, a break. He may say, look, I find the evidence to be true, but I'm going to continue on your probation. And then the next time you may say, I find the evidence to be true. I've given you chance 1, chance 2. Now we're on chance 3. That's it. You're out of chances. I'm going to sentence you to whatever the jail time maximum is. So they can sentence you from 0 all the way up to 180 if it's a class B, 0 up to a year, depending on what, remember, the exposure range is on a class A. And if it's a felony, they can sentence you to whatever that exposure range is, 2 years, 5 years, 10 years. That's why the attorneys, when they're doing their jobs, are paying attention to that first number.
So in this case, where they were facing 6 months in jail, didn't get it, but if they did do 6 months in jail, is that where like the one day counts as 3 days comes in, or do you have to do all 6 calendar months?
So every county is different. So when we talk about jail time, and this is a kind of a different conversation altogether, but to give you an example, in overcrowded jails, they try and get the citizens out. Jails, not prisons. Prisons are parole. Jails are county level offenses, so misdemeanors. So in jail cases, if you're sentenced to, let's say, a year in jail, in Dallas County, they give you 3 for 1 credit. So every day counts as if it was 3 days. In Rockwall, for example, it's day for day. If you get a day, you do a day. You don't get any, they call it trustee credit. And then there are other counties that'll give you like 2 for 1. But it is county by county. So you have to recognize that as the attorney and know if you agree to some sort of a plea bargain where you're pleading them to time. If you're pleading your client to time and you don't have to, it's usually because you don't believe your client will make it on probation. So if they can't make it on probation, take that into consideration when doing your plea bargain if you don't think you can win the case. And then, or the risk of going to trial outweighs the reward. And then make sure you're aware on parole rules, how long it'll take to get paroled out, or for jail time, how long it will take to get out, if you're getting a credit, if you're not getting a credit. Those are things to take into account before a plea bargain is made. But for revocations, it's also something to take into account if you're going to agree, because many times you can negotiate before you get to a judge. In other words, the motion to revoke's filed, no hearing has happened yet. You negotiate with the DA on the appropriate resolution. And the DA can say, yeah, the appropriate resolution is continuing them on probation. And then they withdraw the motion. Or the DA can say the appropriate resolution is to do this class. okay, that's the appropriate resolution. Judge, will you approve this? That can happen prior to a hearing being set. And then the judge can approve or disapprove of that actual plea bargain agreement, right? And you'll do the same type of plea bargain agreement stuff that you did in the original case. It's titled a plea of true, and it's a little bit different. But for the most part, it's a plea bargain that you have agreed with the prosecution. So to recap, hope is not lost if you have a violation. Find a defense lawyer early and make sure that they are talking to the probation department and the prosecutor's office prior to the violation being filed. Talk to the prosecutor's office to see if a resolution can be worked out that does not require a hearing. And then, as a last resort, do a hearing and let the judge decide what is appropriate. Make sure that you have all your ducks in a row, that you explain why you want the resolution that you're asking for, so that the judge just doesn't have to sit there and go, hey, you've not given me something to hang my hat on. Or the prosecutor doesn't sit there and go, you're giving me nothing here. You're just saying, let them do it. Well, most of the time you need to give them something. So in the cases of peeing hot, I like to have my clients go out and do 10 drug tests or 5 drug tests or however many I can do once every 2 weeks to prove that my client is peeing clean and that this is not a problem, that this was a one-time event. If it is, let's say, alcohol violations, which you see a lot for DWI cases, if it's an alcohol violation, again, if you're doing it every 2 weeks, but also showing that you have like an interlock device on your car or something to show that you are consistently doing something that indicates no alcohol. Find a drug and alcohol evaluation that you redo and say this person is not a risk to society because they don't have a problem for these reasons. Have an explanation for whatever the violation is. If it's missing a probation department check-in date, well, we couldn't make it because we were at work, and the reason that we need to be at work is we would have gotten fired otherwise, and we explained this to probation, but they weren't willing to work with us. Have an explanation, have a resolution. I always say, when you go to an employer or a judge, or to a prosecutor for that matter, solve the problem. Don't go to them with a problem. Go to them with a solution to the problem. They all know what the problem is. They're the ones that filed the motion. The judge has seen the motion to revoke, that is. Have a solution so that you're not up there with your proverbial in your hands and just saying, please, please, pretty please. That's not an argument. That is a bad attorney that has not prepared, that has not even spoken to his client. And sometimes I've seen the attorneys, they just put their client on and go, hey, tell him what happened, with no clue from the client as to what to say, no preparation whatsoever. And the client's like, yeah, I did it. Please give me what I'm asking for. Again, not a plan. Have a plan, prep the plan, and execute the plan. So when it comes to motions to revoke, ladies and gentlemen, there is hope. Do not despair. Even if it's your 4th or 5th time, I have managed to get people put back on probation. Even under the worst of circumstances with new offenses. Do not despair. I'll tell you a story to end real quick. We had a client that came to me with a motion to revoke his DWI 4th probation because he had gotten DWI number 5 while on probation for DWI number 4. And he had already served a prison sentence for DWI number 3. He wasn't even probation eligible for DWI number 4, but because the state struck an enhancement paragraph, he was able to get probation. By the way, I was the one able to get him probation on DWI number 4, even though he had gone to prison for DWI number 3. So we got an amazing deal of 5 years of probation on DWI number 4, and he violated that by getting shit can drunk and testing 3 to 4 times the legal limit, and got another DWI. It's not like I could argue that he did not commit the offense. I was unable to argue that. That was not a genuine argument. But he came back. He said, is there any way I don't go to prison? Not just for DWI number 4, but for DWI number 5. He goes to prison. Well, it makes fighting DWI number 5 moot because you're already going to prison for DWI number 4. You might as well roll them into one. And then because it's DWI number 5, the prosecutor was offering me 10 years in that case in prison to resolve it, which was maxed him out. And I said, of course, I'm not going to plead to a maxed out plea offer. It was 10 for 5, so 10 years probated for 5, which means his exposure was 10 years. And we believed if we went to a hearing, the judge very likely was going to give him 5 years to do because he had done 3 years on the previous DWI number 3 or the previous jail sentence. So I thought it was very likely it was an impossibility to win the hearing based on the facts. It was a very likely possibility that he was going to go to prison. And we developed a plan where he entered an inpatient rehab facility. We got the judge to agree to postpone his hearing on his motion to revoke for 6 months while he did 6 months of inpatient treatment, which he successfully completed. We came out of that. The prosecution was so impressed that they gave him probation on DWI number 5 and continued him on probation for DWI number 4. And that man never went to prison. Not on my watch.
That's incredible. But he still was able to get help and finish a rehab and not have to go back to prison. That's incredible.
Allowing me to represent him and get him the help that he so desperately needed, because sometimes our clients do need help. Lawyers out there, there are times to be a lawyer and there are times to be a human. And in this case, I made sure that I was a human first and said, you need help. I'm not simply going to try and find a way out of this. You need help first and foremost. And if you commit yourself to that help, there is a chance that we can show a judge or a prosecutor's office you have changed, because that's what they're looking for ultimately. So don't give up hope. There is a chance you can change. Finding the right lawyer makes all the difference. And with that, that's another episode of Lassiter Law.
Mark Lassiter, you're such a bulldog, and I really appreciate working with you. How do people get a hold of you?
They can reach me at 214-845-7007, or you can email me at markmark@lomtl.com.